Welcome to episode number 227 of AAA Weekly Knowledge Series. Today we will only talk about bankruptcy and bankruptcy trustee. This is based on various questions which has come from our audience because nowadays the new cases which are getting assigned to insolvency professionals are regarding individual insolvency of personal guarantors or bankruptcy matters. So therefore, we prepared this episode 100% focused on bankruptcy and bankruptcy trustee, the duties of bankruptcy trustee, etc. We will also cover latest judicial pronouncements on bankruptcy process. We also have been asked to cover the avoidance transactions, which is an obligation of bankruptcy trustee. To start with, we'll say that this insolvency is a different word and bankruptcy is a different word. The insolvency is a state of financial position of a person or of a legal entity, maybe a company or a limited liability partnership. Whereas bankruptcy is a statutory legal status given to a person who actually is bankrupt as per the definition. Now, the companies are not bankrupt. Companies are insolvent, and in case they are not resolved, then the companies go to liquidation. And in liquidation, finally, the death of the company is sure. Whereas in the case of bankruptcy, which is only in the case of individuals or in the case of partnership firms, in the case of partnership firms, also it depends upon the partner's bankruptcy. So the bankruptcy is when the individual or a partnership firm is not able to honor its debt, its liabilities, then it is a bankruptcy status, and going through this process of bankruptcy will finally lead him to a fresh start. In liquidation, going through the liquidation process, it will be the death of the company after that. In bankruptcy process, after going through the bankruptcy process, it will be a fresh start for human, because bankruptcy or individual insolvency is about humans. It is not about a legal entity. It is not commercial. The entire law has been framed in such a manner that it is to facilitate giving him a fresh economic life to do business, to take decisions. One error should not spoil an entire career of a person, of a human. That is the objective. I was a member of the committee constituted by IBBI and MCA, and our responsibility was to introduce or effectively implement the individual insolvency and specific to the personal guarantors. When we were discussing clause by clause the regulations and the rules, the focus, the mandate which was coming from the lawmakers to us was that it is not about recovery, it is not about the company, it is about a human. We have to think about human, we have to think about his life and his survival, and also the survival of his family and the minimum needs of a human. That is the logic of bankruptcy or even insolvency of a person, of a human. Now let us understand how bankruptcy arises. So there are three statutory gateways for leading to bankruptcy. I will just take up one by one. The very first, and it is, the first gateway is that it should fail the insolvency resolution process of that person. There is no direct way to go to bankruptcy process. It has to lead through insolvency resolution process of an individual. And then even after we initiate the insolvency resolution process, there are three statutory gateways which actually can take you to bankruptcy. One, if an order is passed under section 100, subsection 4, rejecting the insolvency application on the ground that it was made with the intent to defraud creditors, and the report of resolution professional under section 99 says that this is not a correct insolvency application. So that can also lead to, or rather that will lead to, because whenever a rejection order is passed by adjudicating authority, which may be NCLT or DRT, it has to also give a liberty to start and file an application for bankruptcy. So to some extent, this can be considered as a direct route to bankruptcy process. But this is a first statutory gateway application for starting insolvency resolution process getting rejected based on a fraud or based on the report of the resolution professional under section 99, then the order must also give a next status that now the creditor or the debtor are at liberty to file an bankruptcy application. Second, in case the repayment plan which is submitted by the personal guarantor or individual in the insolvency resolution process is rejected by the adjudicating authority, that will also lead to an window for commencing bankruptcy process. Third, an order under section 118 which records that the repayment plan is not getting implemented or the committee of creditors have in fact prematurely closed the repayment plan, then also the bankruptcy process will start or it will get open for the creditor and the debtor to initiate. Now, once the bankruptcy order is passed by the adjudicating authority, as I said, maybe NCLAT or maybe DRT, once the bankruptcy order is passed, it will trigger vesting. Vesting means all the estate of the debtor would vest with the bankruptcy trustee. This is a unique case. Without even any transfer, without any execution, without any document, the bankruptcy trustee will have all the real estate, all the other assets of individual will vest with the bankruptcy trustee. And bankruptcy trustee will be able to dispose those off following the process as per the regulations and as per the rules. Second effect, collective execution. Now all the creditors taken together, they would be collectively deal with the estate of the debtor through the bankruptcy trustee. They will file their claims, they will understand the estate of the debtor, they would also investigate about any estate which is hidden by the debtor. They all collectively will make effort that there should not be anything which is left away, and if there is anything owned by the debtor, that should come to the bankruptcy trustee, that should be disposed of and only to pay off the debts. 3. Status and disabilities. This is a difficult part of the bankruptcy process because this suffers. Once the bankruptcy starts, the bankrupt suffers some disabilities. Now the disabilities under section 140 and section 141, in fact, until the discharge is given, this includes one, that he would not be able to become a director in any company. He would not be able to involve as a promoter, in the formation or in the management of a company. He will also not be able to create any charge on his estate. He will not be able to take any credit beyond the prescribed limit without disclosing bankrupt status. And he would also be debarred from traveling overseas without the permission of the adjudicating authority. So these are the disabilities once the bankruptcy order is passed. The fourth is the administration. So the bankruptcy trustee investigates the affairs of bankrupt, realizes the estate and distributes it to the creditors. And then finally, the beautiful part of the bankruptcy process is that under section 138 of the code, the bankrupt will get full discharge. Now that discharge means that he will be discharged from all his obligations, liabilities, financial liabilities, not the criminal one. I will come to those things which are excluded debts. We will talk about excluded debts and excluded assets. Now this is very important that he gets discharged. So after the discharge, even if the bankrupt gets a lottery of say 500 crores, none of the earlier creditor will come and claim anything because now you have this amount, now you are a rich man, but there is no claim lies in the eyes of law. So that is where the complete discharge. He would be able to own a company, he would be able to promote a company, he would be able to start a company, he would be able to own home, he would be able to own a car, and he can actually live life, earn, and like a normal human being without any stigma of the bankruptcy process. This is the beautiful part of the bankruptcy process. Once the bankruptcy trustee is appointed, first of all, who can be appointed as bankruptcy trustee? It is very clear that the insolvency professional who actually has a valid AFA can be appointed as insolvency professional on the insolvency resolution process of the debtor. Now, once the bankruptcy order is passed, so the same person will be appointed as bankruptcy trustee. In some cases, there is a possibility that the creditors can opt for a different bankruptcy trustee because the insolvency professional is not interested in continuing. So therefore, they can actually appoint somebody else. Once the bankruptcy trustee is appointed, he actually has different positions in this entire process. The first position that he actually will have and responsibility that he will have is the investigator. He would be the investigator of the bankrupt's affair and antecedent transaction. First role. Second role will be custodian. He will actually be custodian of all the estate of the bankruptcy trustee. Third role, realizer. He will convert all this estate assets in distributable funds and also will recover money out of the avoidance transactions in case there are any undervalued transactions, preferential transactions, and also these transactions. And finally, he will have to act as a distributor under section 178 because there is a waterfall arrangement that he will distribute whatever he has collected, realized, he will distribute as per the waterfall arrangement provided in section 178. Like we have section 53 in the case of liquidation of companies, we have section 178 in the case of bankrupts. Now, coming to the excluded assets. So first of all, excluded assets means that we said that the the bankruptcy trustee will have the vesting rights of all the assets of the bankrupt and he will have the right to dispose of. But there are some exceptions. Now, excluded assets are those where the bankruptcy trustee will not have any right to take it over, get the vesting rights, get the disposal rights. So those rights are restricted, and these excluded assets are minimum assets which are required for a human being to live, to earn, and to feed the family. This is the law which protects humans. So these excluded assets are those assets which are minimum need of a human. Let us start with first. Unencumbered tools, books, vehicles, and other equipment necessary for debtor's personal use in employment, business, or vacation. Now, everyone has a right to be employed, do a business or a vacation. Any unencumbered, which is not kind of pledged or mortgaged to anyone, like those tools or books or vehicles and other equipment necessary for debtor's personal use. So, anything which is used personally. Now, there can be a litigation that whatever plant and machinery I have, that is my tools. But the word written is debtor's personal use. Personal use. So which the debtor is using. For example, if he's a carpenter, if he's a painter. So all these equipment, whatever he is using for earning, for doing a business, for doing a job, that actually is an excluded asset and that cannot be taken over by bankruptcy trust. There can be a lot of litigation, but finally, the intent is that it should be the minimum survival kit. If something which is beyond the minimum survival kit, that can be vested with the bankruptcy trustee, even if there is any litigation, even if the bankrupt goes to any kind of adjudicating authority, if it is beyond the survival kit, it will be not considered as excluded debt. So the first and foremost test is it should be a survival kit for a person. Second, unencumbered furniture, household equipment, and provisions necessary for basic domestic needs. Now, the last word, necessary for basic domestic needs. No, the bankruptcy trustee cannot take away his chairs and furniture and sofa and household equipment, his cooking range. He can't take away because that is the minimum thing which is required which is necessary for basic domestic need. Human is a domestic person. He needs something which is for his domestic minimum need. Now, if somebody says that I have a sofa which is made of gold, no, that is not the basic domestic needs. That is not. If somebody says that I have a Mercedes car and I use this car for going to my office, no, that's not a basic need. That's not a basic vehicle. So that is something which is to be decided by the adjudicating authority in case-to-case basis. But the basic concept is that it should be basic domestic needs, so that all is excluded. Personal ornaments of religious significance which cannot be parted with up to a prescribed value. Presently, it is rupees 1 lakh as per 2019 rules. It is only 1 lakh. So in case there is any Mangal Sutra, if there is any Kara, anything which is religiously important, or it cannot be parted away as per the rituals. If it has a value of 1 lakh or less, it will not be touched by the bankruptcy trustee, and it will not be considered as estate which gets vested in bankruptcy trustee. So this is the third excluded asset. I'm going to 4 unencumbered life insurance policies and pension plans. Life insurance policies and pension plan without any limit. So there is no limit mentioned here, because this is something that you cannot create overnight. It has to come as a legacy. So it is very difficult to plan, but yes, these are excluded. An unencumbered single dwelling unit up to a prescribed value. A human has to live somewhere. So therefore there is an exception. Presently it is 20 lakhs of rupees in urban areas and 10 lakhs of rupees in rural area. Any home, any dwelling unit which has a value of 20 lakhs in urban areas and 10 lakhs in rural area is an excluded asset. The bankruptcy trustee cannot touch it. This value is lower, we understand that, but the law is for the entire country. It is not only for Delhi. But yes, when it was being discussed in the committee, it was also discussed that if the value is more, if the value that a house in which he is living already is having a value of say 1 crore, then the bankruptcy trustee can take over that house and give that particular person 20 lakhs of rupees so that he can live somewhere else and in that particular value. So that was discussed amongst the professionals, amongst the committee members, but then there is no adjudication so far on this. So the dwelling unit we've already touched, and then so these are the assets. Like there are 5 excluded assets which cannot enter the estate of the bankrupt. The bankruptcy trustee cannot touch these assets, which are basically for minimum survival kit of a human and his family. Now, also we talked about discharge to a bankrupt after the conclusion of the bankruptcy process. The bankrupt will be given complete discharge under section 138 of the code. Now, the discharge is on all the financial obligations, but there is no kind of exemptions to the criminal part of it, fines, non-compliances. So these are the excluded debt. Even if there is a discharge under section 138 by the adjudicating authority, the bankrupt will have to abide by law and will have to pay the following debts. Now, these debts are not extinguished. So what are those debts which are not extinguished even after having discharge? One is any fine imposed by a court or a tribunal. Now, there is a difference between fine and penalty. Now, if there is a penalty by the income tax department or by the GST department, that is a penalty, that's a financial liability. But fine is basically out of a criminal non-compliance. So whenever we see any offense, when it comes to offense, it is the outcome is fine or imprisonment or both. Fine or imprisonment or both. So this is not extinguished. If there is a fine, it cannot be extinguished. If there is a penalty, it will be extinguished. Income tax penalty extinguished, GST penalty extinguished, any other penalty extinguished, but if it is a fine. So the fine is an outcome of an offense. Offense is a criminal part. Coming to the liability to pay damages for negligence, nuisance or breach of statutory, contractual or other legal obligation. Now, this is also something which is to make a person disciplined. Any liability to pay damages. Now, the damages is also an outcome of negligence, nuisance or breach of statutory, contractual or other legal obligation. Now, I have an obligation to drive my car carefully. If I cause an accident and out of that accident the court directs me to pay some damages to the person affected. Court directs me to pay some damages to the municipal corporation where the property is destroyed by your car. It is only because of my negligence, my nuisance or breach of a statutory, contractual or the legal obligation. It is my legal obligation to stay compliant, to drive carefully. I am not supposed to do the negligence. So therefore, in case of any such damages awarded by any court or any tribunal, that cannot be extinguished, that will have to be paid. So in case I hurt someone and the court says that you have to pay 10 lakhs of rupees to the person, so that is the damages and that I will have to pay. It will not be extinguished. Coming to the next part is the maintenance liability. Now, the maintenance liabilities are, for example, in case of any marital dispute or any kind of divorce, if the court says that you have to pay the maintenance to your spouse, and this is the maintenance that is liable to be paid, so that maintenance cannot be extinguished. It will not be waived even if you have a discharge from court under section 138 of the code. So that will not be extinguished. So you will have to pay that maintenance to your spouse. Next is the student loan. If any loan which is considered to be a student loan, that also cannot be waived, because see, if I at young age, if I take loan of, nowadays the loans are very expensive and it is huge, the cost of education has gone very high. There are cases where the individuals have taken a loan of say 1 crore of rupees, and immediately after that qualification, if he declares himself as bankrupt and he gets the waiver, and many people will prefer this rather than paying the installments for the next 15 years. So therefore, thoughtfully, the lawmakers have decided that the student loan would not be extinguished. And then there are many other debts which may be prescribed by the lawmakers from time to time. So this is something which is very important. The law for insolvency of personal guarantors, in fact, got notified in 2019. And after that, it actually got constitutional validity from Honorable Supreme Court. And thereafter, it actually started rather implementation. Initially, a lot of applications were filed by the debtors because of one section which says that on the filing of the application, the debtor will have the advantage of a moratorium. Now, what is that advantage of moratorium? That once the application is submitted to NCLT or the DRT, no creditor can take any coercive action for recovery of debt. They cannot even invoke SARFAESI action, even if the assets are mortgaged to them. So this was the best use that the debtors could take. All the creditors, in fact, they were reaching out to lawmakers that this particular law has disturbed their recovery processes. The moment Section 13 subsection 2 notice is given to debtor, and if he is a grantor also in a company or in a limited liability partnership, he will immediately file application under section 94 for the individual insolvency resolution process, and immediately he will claim that moratorium, and it was being allowed by all the courts because the law was very clear. To that extent that many matters in fact went to various courts, and it was held that the law is very clear that the moratorium starts at filing of the application, and therefore it was given. So then also there are many cases. I will just take out some of the cases. Like in one case, even the moratorium was claimed under section 138 of the Negotiable Instrument Act against the dishonor of checks. So there was one case which was Rakesh Banot versus Gurdas Agro, where it was held that this protective moratorium does not stay section 138 of Negotiable Instrument Act, because this prosecutions, penal and personal, and not legal action in respect of a debt. So the prosecutions under section 138 of the Negotiable Instrument Act are penal, and these are personal, and these are not something legal action in respect of a debt. Similarly, in the case of Saranga Agarwal, likewise, they wanted that all the regulatory and consumer penalties like NCD, RC, execution, that also should be under moratorium, but the courts have said that these are regulatory issues, these are penalties which cannot be considered as legal action in respect of a debt. In another case, which is in Dinesh Chand Surana versus UCO Bank, and that is a very recent case, that's in May 2026, the Supreme Court in fact referred the section 138 question to a larger bench. Because see, in this Dinesh Chand Surana versus UCO Bank, in the Supreme Court in fact referred this matter to a larger bench, because this is pending as on today. We are release of the episode. The significance is that this ratio, like the check bouncing, whether it would be considered as a legal action or whether it would be considered as a criminal action. So that is a matter which is pending with a larger bench. Then suffered from all this, we also have the kind of amendments which actually came to the light, and those amendments under in IBC 2026. So this was in fact amended this was amended like in both cases. They in fact inserted a clause subsection 4 in section 96 which were talking about this moratorium at the time of filing of an application, and also under section 124 when a bankruptcy application is filed. So this amendment was in fact effective from 26th May 2026, and it is very clear that on filing of the application for insolvency resolution process of a debtor, the moratorium would not start. The moratorium will start only once the NCLT admits the case and the insolvency resolution process starts. This is the amendment which actually has given relief to lenders, and now the section 94 applications are reduced to a greater extent, but 95 is now it is an obligation of all the lenders that they should file the application under section 95 for the insolvency resolution process or for the bankruptcy of the bankrupts. Now this amendment, which is although it is the amendment law was effective from 26th of May 2026, this amendment is applicable on all existing cases where such moratorium is already given and the applications are still not admitted. Now, this is held very recently. It has been held by Bombay High Court in the case of Tata Capital Financial Services Limited versus Neil Motors LLP. So this was a case. In fact, it is very recent, August 2026, and it has been held by Bombay High Court that section 96 subsection 4 applies to applications already pending on 26th May 2026. The provision is retroactive in operation, not retrospective in the objectionable sense. It is retroactive. So all those applications which are pending will also not have the moratorium benefit. This is a single most consequential change for the personal guarantor's practice and deserves its own complete discussion. And thus, as I already discussed, that the difficulty is now better handled by the lawmakers. So this is the amendment which actually we are talking about, and this amendment in fact is giving a lot of relief to the lenders. In the cases of personal insolvency, there is a huge difference between the resolution professional and the bankruptcy trustee. A resolution professional is only trying to resolve the insolvency of the debtor, whereas the bankruptcy trustee is having a much larger powers to handle the bankrupt. Now, we will restrict ourselves to bankrupt and bankruptcy trustee. Now, the bankruptcy trustee will continue to have the same kind of claims and will verify the claims, will also take control and custody of all the assets of the bankrupt, will also investigate into the affairs of the bankrupt to find out the assets, will take also kind of undertakings so that he doesn't hide any assets, will also take information from the creditors, claimants about the assets of the bankrupt. He, with the approval of the committee of creditors, can also engage investigators or even forensic experts to find out the assets which are in the name of the bankrupt. All this process will continue, but the most important difference between the resolution professional in the case of personal guarantors and the bankruptcy trustee is the avoidance transaction. Now, the resolution professional does not have any power to find out avoidance transactions and also to try to recover something which has been lost in avoidance transactions. Whereas the bankruptcy trustee has this prime role to find out the money that has been lost in the avoidance transactions and try to recover it so that it is distributed to the creditors. So the first thing, that if anything is sold or disposed of by the bankrupt after the start of bankruptcy process, that is void ab initio. No buyer will get any title. Although in the case of undervalued transactions, the genuine buyer who has paid the consideration has some protection. But in case any asset is sold after the commencement of insolvency or bankruptcy, that is void ab initio. Then the kind of interplay with the vesting, that means the estate vests in the trustee on the bankruptcy order. The bankrupt therefore has nothing to convey. So it automatically vests, and it is nothing that the bankrupt can convey to anyone because it is already vested with the BT, bankruptcy trustee. Now, the most important transactions that the bankruptcy trustee will find is the undervalued transactions, and the section deals with undervalued transaction is 164. Though the look back period, as we have now seen that it is in the case of section 45, also the look back period has gone back. Now in this case also the look back period is 2 years ending on the date of application for bankruptcy, not for insolvency process. 2 years ending on the date of application for bankruptcy. So application is submitted today and the bankruptcy process may start after a year, but the 2-year period will start from today, and the bankruptcy trustee can go 2 years back to find any transaction of undervalued transaction. So that is what is the look back period, and what is not allowed and what can be considered as a undervalued transaction. One, in case the bankrupt has made a gift. Gift means without any consideration transferring title of any property. Two, transferred property for no consideration. I mean, if it is not a gift, then transfer without a consideration. That will also be tantamount to gift. Third, transfer for a consideration significantly less in value than that provided by the bankrupt. Because see, in case the bankrupt, that's the value is significantly less than. Entered into the transaction in consideration of marriage. In each case, a transaction not in the ordinary course, because see, all these transactions should not be in the ordinary course of the affairs of the bankrupt. And at a time when the bankrupt was insolvent or became insolvent in consequence. So this, if the transaction is in ordinary course of the affairs of the bankrupt's routine, then it is not undervalued, and the burden is on the transaction is on the trustee proves the transaction. It is not on the bankrupt. It is the trustee will prove the transaction, and the window and the value gap, that also has to be proved by the bankruptcy trustee. And then insolvency at the time is presumed where the counterparty is an associate. So in the case of companies or in the case of LLPs, we have seen the related party concept. So this is a related party of the CD, this is a related party of the CD. So these are associates. In the personal insolvency, that related party is known as, it is defined as associate. If any transaction has happened with an associate, and that associate includes partners, relatives, and like the complete definition of associate is given, and therefore if any transaction with the associate is considered to be a transaction which is supposed to be reported to the adjudicating authority. So any transaction within the look back period with an associate will be considered as reportable to the adjudicating authority, and then the adjudicating authority will decide whether it is undervalued or not. So therefore, if any transaction has happened within the look back period with an associate, related party, partner, relative of a partner, all these transactions will be considered as avoidance transaction, and the NCLT will decide. Now the respondents can be all those who actually have got the asset. They can be made respondents. Transferees can be made respondents, and the relief, of course, like the relief in section 45, we can actually go back to the original scene. We can recover the undervaluation. All this is the transaction. The valuation also can be done. Forensic report can also be obtained, and this is something which is very clear that these most of the transaction will be found as undervalued transactions. And one which is very important part is that there is no section like 66 in the case of CIRP. So there is no fraudulent or the doubtful trading transactions. There are no fraudulent transactions in the individual insolvency. Now the other avoidance transaction that we can deal with is a preference transaction, and the section deals with is section 65. Now again, as we have seen in section 43, the preferential transaction is again the look back period is 2 years ending on the date of the bankruptcy application. Preference to any other person as compared to his rights under section 178, because there is a waterfall mechanism. There is a priority given in section 178, similar to section 58 in the case of CIRP or in the case of liquidation. Now, section 178 defines the priorities. In case there is any preference which is given to any antecedent creditor, and that antecedent creditor gets some benefit of priority, that is considered as preferential transaction. Look back period is same as 2 years from the 2 years behind the date of filing of the application for bankruptcy, and also that preference, it should not be in a ordinary course of affairs of the bankrupt. The burden to prove that it is a preferential transaction is on the bankruptcy trustee. The respondents can be made, although the beneficial parties who have got the benefit, those all can be made as the parties which are beneficial. Third avoidance transaction is extortionate credit transaction. Section 167 deals with it, and again the look back period is 2 years starting and going back from the date of the bankruptcy commencement date. So it is 2 years. It is from the bankruptcy commencement date. It is not from the application date. So this is slightly different. And again, we actually have to find out all those transactions which are extortionate as far as these credit transactions are concerned. So very important that transactions with any associate, that is something which actually needs to be avoided. Now we can talk about a very practical part of the function of bankruptcy trustee, that is asset tracing. Because if the assets are traced, then only there will be any function to perform. See, first of all, we'll see that what are the legal toolkit available with the bankruptcy trustee. We'll come to the practical part, how to trace the assets. So the first thing that is very complete legal toolkit is vesting rights under section 128 and 154. That is, automatically all the assets owned by the bankrupt will actually vest with the bankruptcy trustee without any document. And the second is like it is compelling disclosure, because the bankrupt is compelled to disclose, otherwise he will face the consequences which are very kind of harsh. The bankrupt will have to disclose under section 129 and 150 the entire financial position, asset, and will have to assist the bankruptcy trustee in tracing assets. The third section is 156 and 157, where it is very clear that any other person who has any asset in possession which is owned by the bankrupt can give direct delivery to the bankruptcy trustee. Then any disposition after the start of the insolvency resolution process or the bankruptcy trustee, that actually will be considered void ab initio. And then any kind of property which is found under the avoidance transactions like 164, 165, 167, and then there are possibilities of various investigations that can be done by the bankruptcy trustee so that the assets are traced and then appropriately actions can be taken. Some of the practical part of asset tracing we can actually find, because there are agencies now which started working to find out the assets owned by bankrupts, like searching the records of sub-registrars, the state land records, revenue and mutation records, any kind of transaction regarding the conveyances, gift deeds, mortgages, historic transactions with dates and consideration, all can be found now because of the digitization of the records at registrar offices. Then the searches can be made on the MCA 21 website, ROC filings, like all the directorships held by the bankrupt, shareholdings, limited liability partnership in trusts, various charges related to various properties. Because see, when the banks file any charge, the banks also file the sanction letter, and in those sanction letters also have those properties which are owned by individuals and still mortgaged to the banks. Then we actually can find out some of the security interests which are registered with SARFAESI. Then we can also look into the depositories like NSDL, CDSL, the transfer agents, bank statements. We can also see the income tax records, because in few cases that we access to the income tax department, and the income tax department provided us the information about that bankrupt. And we, in the income tax records now, we get the information about most of the interest income which is coming, the bank account details, so the various other investments also, because all this information is in the AIR or 26 AS. That is also available. Then we can even find out the portal, Government of India portal called Vahan for all vehicle registration. We can also find IPR registers. We can also form the arms and license registers. We can find out the court records like DRT, SARFAESI. So in case there is any asset, we can also see the pension and the insurance records, open source. So this is all based on the now the AI time, artificial intelligence time. We can find out the assets quickly and better as compared to the past. So in case we find assets, then we actually have a right of vesting immediately, that whenever we find any asset owned in the name of owned by the bankrupt, immediately it gets vested with the bankruptcy trustee. At last, I will discuss very recent judgments on bankruptcy, which are very important. So the first judgment I will discuss is the Nuzhat Aisha Nasir versus Canara Bank and others. It is a judgment from NCLAT Chennai bench, and this judgment is dated 4th August 2026. A very important judgment, and the question of law in this case is whether personal guarantors already facing bankruptcy proceedings can still be given an opportunity under section 142 of the IBC to work out repayment with the bankruptcy trustee, despite their earlier failure to submit a repayment plan and the limitation objection under section 121. No, the NCLAT has held its very important part. Section 142 reflects the legislative intent to give personal guarantors optimum opportunities to save their honor and dignity. An aspect ingrained in Article 21, it empowers the tribunal, even suo motu, to discharge the bankrupt or recall the bankruptcy order when the debt and the bankruptcy expenses are paid or secured. The legislature shows greater sympathy to debt trapped individuals than to companies, and the apparent unimpressive prior conduct could not outweigh this statutory intent. The appellant were accordingly directed to work out a repayment plan of action with the bankruptcy trustee after first complying with section 150 disclosures. Meanwhile, the trustee shall not alienate any of their assets, and the matter will be listed again for monitoring. That's what is the new experiment which is being done by NCLAT Chennai, that the insolvency resolution process is over. Bankruptcy application is pending before the bench. Now the bankrupt is coming and suggesting that I would like to settle, I would like to submit a repayment plan. So that means going back. So NCLAT allowed it because it is something that he has a right to save his honor and dignity. It is a law regarding humans. It is something that we should try. That's what is said in Article 21. In another judgment, which is Cosmos Cooperative Bank Limited versus Anil Kumar Gilera, again the judgment is dated 30th of June 2026, and the question of law in this case is whether the 3-month period for filing a bankruptcy application under section 121 is mandatory or directory, and whether delay can be condoned under section 238A of the code read with section 5 of the Limitation Act 1963. Now in this case, the NCLAT held that section 121, although it uses the word shall, prescribes only an inner timeline and no outer limit and no consequence for non-compliance. Now let us understand the intent. The intent is that within 3 months you can file an application for bankruptcy in case the resolution process fails. Now in case nobody files an application for bankruptcy, then what happens? Then again the insolvency process will start again, or what? So therefore the NCLAT said that even if the 3 months have already passed, and in this particular case there was a delay of 160 days, that means the 3 months plus another say 5-6 months, so it was delayed this much, but the bankruptcy application was filed because the insolvency has actually failed. So the NCLAT in fact condoned the delay, and NCLAT, it is basically considering the design deliberately keeps personal insolvency non-rigid. The 3 months window is facilitative, preserving room for settlement. Given the Article 21 dimension of individual bankruptcy, in the absence of express exclusion, Section 238A attracts Section 5 of the Limitation Act, empowering condonation on sufficient cause. So this was a sufficient cause that a person has a right, and he actually has a right to get a discharge, and even if the insolvency resolution process failed and he is not able to file the application for bankruptcy process within 3 months, yes, the condonation can be granted. Very recent judgment. Another judgment is in the name of Akshat Gupta versus Union Bank of India and others. It is again an NCLAT judgment and it is decided on 25th of March 2026. It's an appeal by an auction purchaser in the bankruptcy process, and the question of law is whether the NCLT was justified in setting aside a completed e-auction of the bankrupt's 50% undivided share in the residential flat, where the sales certificate had issued and full consideration was paid on grounds of a shortened 25-day notice period and other procedural irregularities by the bankruptcy trustee. Now, in this case, the NCLAT held that yes, it was right to set aside if proper notice was not given. The notice requirement is 30 days, whereas it was only 25 days notice, and let us understand what the finally held. The appeal by the auction purchaser dismissed the personal grantor bankruptcies. In personal grantor bankruptcies, NCLT exercise the powers of DRT and must follow DRT norms, including the 30 days notice period for auctions under SARFAESI law. A 25 days notice for a complex half asset was inadequate. The trustee also informed the COC of the valuation, auction, and sale only after completing each step. Such post facto sharing treats the COC as a post box and is contrary to the IBC. So this was auction under IBC was related to DRT and SARFAESI, where the 30 days notices must, so all the bankruptcy trustees must follow that in case there is any asset to be sold, they must give at least 30 days notice, which is prescribed under SARFAESI law. Now, another judgment which is in the case of Anil Goel versus Ajay Gupta and others, that is decided on 8th July 2025, and that question of law is whether the bankruptcy trustee's duty under section 138 to apply for discharge on expiry of 1 year from the bankruptcy commencement date is mandatory, and whether the bankrupt has locus to seek discharge when the trustee fails to file their application. The NCLAT decided yes for both. First, whether the bankruptcy trustee has a judicial duty to file a discharge application after the expiry of 1 year. Yes. Second, whether the bankrupt has a locus to seek discharge when the trustee fails to file that application. Yes. The court says that yes. Only why? Because section 138 uses shall and casts a statutory obligation on the bankruptcy trustee to apply for discharge on expiry of 1 year or within 7 days of the COC approval of the completed administration, tracing the legislative history and BLRC report, envisaging discharge at the end of 1 year. The tribunal held the trustee cannot shrink this duty on the pretext of awaiting the creditor's consent or a legal opinion. So therefore, it was the duty of the bankruptcy trustee to file a discharge application. In case he fails to, then the bankrupt can file the application himself so that he can protect himself, he can seek his discharge. Now it is the last judgment that I would like to share with you, and that is also dated 25th of June 2026 in the case of Joseph Raj versus PR Raman, and in the question of law in this case is whether a shareholder cum personal grantor subsequently declared bankrupt under section 121 and 123 of the IBC has locus to challenge a concluded liquidation e-auction, and whether such an auction, once confirmed with full consideration paid and sales certificate issued, can be set aside on unsubstantiated allegations of fraud and procedural irregularity. The case is mixed. In this case, there are 3-4 things that actually was used. One, the personal grantor is now bankrupt, and whether he has any locus to object to any sale which is already concluded, and the allegations of fraud and procedural irregularity is unsubstantiated. So therefore, the court said that person, the shareholder cum personal grantor, has no locus. So these are the latest 5 judgments which are on bankruptcy process to be used by bankruptcy trustees and insolvency professionals. I hope the information about bankruptcy trustee and the bankruptcy process is useful to you. In case you like these kind of subjects, therefore you can hit bell icon on AAA Insolvency YouTube channel so that you get alert. Earlier I was sending you the messages through WhatsApp, but because of the limitation on WhatsApp broadcasting, it is not really possible to send messages. So therefore I would suggest that you subscribe to this channel so that you get alert. Invariably, we publish a new video every Saturday at 11 a.m. Thank you very much for bearing with us. Thank you very much.